Hi, everyone. We're going to just take another couple minutes to let everybody get in here, but we will be discussing the complicated verdict in the criminal trial of Roman Storm, which just completed. I'll apologize in advance. I'm exhausted. I'm sure a lot of other people are here too, but we'll do our best starting here very soon.
Cool. Yeah, I hope this is all working as intended. I think everybody's up here that we've spoken to that will be speaking. Very dark day for non-custodial software developers in the US. Um, Probably not such a terrible outcome for Roman Storm. As I understand, he could have faced 45 years in prison and now is facing a maximum of 5. Um, so we're gonna wait maybe like another minute or two for a couple more people to join. And then I think the first question to our speakers, that's probably bugging everyone here right now is what does this mean for other software developers? Does this set precedent? What kind of a precedent does it set? What does persuasive precedent even mean? So we're going to give it maybe a couple more minutes. We have Peter Van Valkenburg, who's the executive director, I think, of Coin Center, and Amanda Tuminelli, who is the executive director of the DeFi Education Fund. Both of them are parties to the case. Peter's Coin Center has filed amicus curiae briefs on the free speech aspect, I believe, of Roman's prosecution. And the DeFi Education Fund has filed an amicus curiae brief specifically on the 1960 charge. So we'll give it maybe another minute, and then we'll get going. Okay, I think there's a lot of people here already. This space is also recorded, so if you didn't catch the beginning of this, you can always go back and listen. Maybe we should start with like a quick round of introductions from everyone. Peter, if you want to go first.
Yeah, hi everyone. I'm Peter Van Valkenburg. As Lola said, I'm the executive director of Coin Center, an independent nonprofit based in Washington, D.C., focused on cryptocurrency policy. And we did file an amicus curiae brief in the Storm trial. We're also supporting developer Michael Llewellyn, who is suing the DOJ in Fort Worth, Texas, for declarative judgment that the software he wants to publish is not going to land him with an unlicensed money transmission charge.
Amanda, are you there? You want to go?
Yep, I'm here. Hopefully you can hear me. I apologize if I go in and out. Hi, everyone. I'm the executive director at the DeFi Education Fund. We are a nonpartisan nonprofit advocating for sound DeFi policy, and specifically for software developers like Roman. We also put an amicus brief into this case, arguing that counts 1 and 3, the 2 counts that the jury just hung on, were also inappropriate because they rest on a very flawed principle that software developers can be held responsible for the conduct of third parties. We've since written extensively on Section 1960. I wrote a 40-page paper on 1960 with Jake Chervinsky and Dan Barabender, and have done a lot of work with Coin Center on this subject to make sure that people understand how flawed the DOJ's interpretation of 1960 is.
Thanks. I guess I'll jump in and just introduce myself briefly for anybody who doesn't know. My name is David Z. Morris. I have been covering the trial on a day-to-day basis in collaboration with Lola and the Rage. So my brain is really, really melty at this point. So I'll apologize again in advance for that. Previously, I was chief columnist for CoinDesk when that was still a legitimate news publication. And prior to that, I was the managing editor of Fortune's crypto newsletter, and have studied this kind of stuff for a long time. So that is me. Lola, you want to just talk a little bit about yourself?
Sure. My name's Lola Leeds. I'm an independent journalist. I've also written for CoinDesk, Bitcoin Magazine, some other stuff as well. Um, so I think the most pressing question right now that everybody's worried about is, what does this mean for software in the US, this conviction on this one charge? As far as I understand, it's a persuasive precedent, which means that it's not necessarily to be followed by other courts, but it seems from the general landscape, I believe, it seems that this is something that may be likely. So maybe either Amanda or Peter, you want to take it away on that and explain what this means?
I'm happy to start. So I think I don't want to be too disastrous in tone here, right? This is one jury verdict in one district court in the country. This is not binding on other courts. It's not even binding in the Southern District of New York. That being said, it is obviously not a great thing for software development in general, not even just software development in crypto, because the DOJ's theory in this case has now been validated by at least one jury, and there were obviously the guilty pleas to Section 1960 and the Samurai Wallet developers case just a week ago. So what the problem is, the DOJ's theory is that transferring funds on behalf of other people can somehow be interpreted to mean writing code that allows other people to transfer their own funds. That is obviously illogical and not how the tech works, but that is their theory and has been their theory in this case. So when I say that, it's bad for software development in general, it's because there are developers of neutral tools who have no control over how other people use their tools. And in this case, the DOJ has taken the position that even a developer of an immutable software protocol who can't control anything that anybody does with that code once it's been deployed is now responsible for people transferring their own funds. It's a misinterpretation of Section 1960, and obviously we don't want to see that misinterpretation get repeated in another case.
The only thing I'd add to Amanda's excellent answer, and she has more litigation experience than I do, so I'm glad she went first, is that it's worth noting that venue and jurisdiction here are kind of crazy. It's not like Roman was a New Yorker who was like walking around in lower Manhattan when he got arrested for publishing software. He lived in Washington State, I believe. And, some friends who know the courts better than I have for a while referred to the Southern District of New York as the sovereign district of New York because they want to be the world's policeman for financial crimes, right? So, yes, this is just one jury in one district. But as Amanda said, once they prove that they can bring these prosecutions this way, it becomes a blunt instrument that they can go out and seek jurisdiction over anyone, anywhere around the world, rein them in and bring them to New York, and then charge them and get another, hopefully it wouldn't be, but another guilty verdict. And all they need to do is prove that somebody in lower Manhattan or in New York used that software, right? And that's actually what they do. This is public fact. They have investigators who are their employees install the Samurai Wallet software on a phone, and then they claim jurisdiction over them. So you might think you live in Kuala Lumpur or Los Angeles or Nashville, Tennessee, and so this is none of your affair. This is your affair. And this is also why I think it's really important for us to have parallel legal challenges, and why Coin Center is so willing and excited to support Michael Llewellyn, as I said earlier, a developer out of Fort Worth, Texas, who was willing to stand up and sue the Department of Justice for declarative judgment, saying basically, I don't want to publish the software I was about to publish because it's privacy related. It allows other people to move money. I don't want to publish that software if I'm going to be wrongly accused of unlicensed money transmission. And so, hopefully, Michael Llewellyn's case right now is facing a motion for dismissal from Pam Bondi's DOJ. And it's my hope that the court will see through that call for dismissal. The dismissal says that Michael faces no credible threat of enforcement. Meanwhile, the DOJ has actually just, found someone guilty of essentially the same, course of conduct. So it's my hope that Michael will get over that motion to dismissal phase, and we'll actually get another court weighing in on these important legal issues. And I also, of course, hope that Roman appeals the bad law that was made during the motion to dismiss phase in his case last winter, where the judge sort of foreclosed any reasonable interpretation of what qualifies as money transmission. Like, that wasn't a jury choice at the end of the day. The jury didn't have many options in this case. That was some legal choices made last winter. So I think we've got many roads to make this better, but it is pretty bad right now.
Thanks for that, guys. I actually have a follow-up on that. First, I do want to just say, so that nobody gets too confused, Peter's comments about, the venue issue and the reach for venue, that was definitely particularly a reach in Roman's case, and we can talk about that in more detail if we want to. But I do want to make sure people understand that this is very widespread practice for Southern District of New York. They reach out and touch anything that's financial, and a lot of the time, well, in the past, it has been because so many banks are in New York. Obviously, we're seeing them try to carry that forward into an era where their centralized entities are no longer in their jurisdiction. So, but the question that I had was on this money transmission charge, where we did get a conviction. There was also sort of shifting ground, I would say broadly, as to the actual charge that was being emphasized or prosecuted. And I, to be frank, despite watching the entire trial, was never entirely clear on these fine distinctions. 1960 has, I believe, 3 prongs, of which one is failure to register, which I think is A, and was not, I think, what they actively pressed on in this trial after some decision making early on. The part that he was the emphasis of the trial, and that he, I believe, substantially was convicted on, had to do with knowingly handling criminal proceeds as a money transmitter, which, as some have commented, is interesting because they're no longer focusing on the failure to register as a money transmitter, but treating them as engaging in criminal transfer in that role. So could either Peter or Amanda, can you talk about the sort of subdivision of that 1960 charge, and whether that might play a role in especially the ability of this to act as precedent if there was sort of shifting grounds for the charge?
Yeah, happy to. And your introduction was exactly right. There are registration prongs. So 1960 B1A is a state registration prong if you fail to get a state license for money transmission. B1B is a federal licensing registration related provision, and that was originally at issue in this case, but the DOJ chose not to pursue an allegation that Roman conspired to violate 1960 B1B, the federal registration provision, but they kept 1960 B1C, which is, as you said, when a person transfers funds on behalf of the public, knowing those funds are the proceeds of a crime. Any 1960 provision, any allegation under 1960 is that to even be talking about 1960, you have to be talking about money transmitting, which is defined in 1960 B2, and it's defined as transferring funds on behalf of the public. And I think it's pretty clear from that language, right? I can't transfer your funds if I don't have them in my possession and in my control. So when you're talking about a software developer with no control over anybody else's funds, you are not talking about money transmitting. And as I'm sure many people here know, in 2019, FinCEN put out guidance, and FinCEN is the regulator for money transmitting businesses. And FinCEN said, if you are just a software provider who does not have total independent control over any customer's funds, then you are not transmitting money. But the DOJ said they don't have to listen to that guidance, right? They can come up with their own interpretation of 1960 and misinterpret it to mean that even a software developer could be transmitting other people's funds. So it's really problematic the way that they've done that in this case. But the conviction is a conspiracy to violate 1960 B1C, which is, as you said, knowingly transferring criminal proceeds on behalf of the public.
And there's something that, you might say, well, the criminal code seems kind of crazy here. And to some extent it does. It's odd that in a bracket of charges that are all called unlicensed money transmission charges, they're all being charged with unlicensed money transmission, there'd be a sub bracket that has nothing to do with licensing, right? So that A1 is licensing with states, that B1 is
Yeah,
registering
very confusing.
with the federal government. The C1 doesn't say you're doing unlicensed. It just says you knowingly transmitted. I agree with Amanda. All three of them have as a predicate, as a requirement, that you are a transmitter. So what is C doing? To my understanding, like C would make sense if you had like Venmo, who is licensed as a money transmitter, but they knowingly transmitted criminal funds. You could charge them with C, right? They're obviously a money transmitter. They did license, so we can't charge them with A or B. So we'll charge them with C. This notion of using B1C to charge someone who is not even transmitting is really an absurdity, because it now says any individual, if you omit the transmission predicate requirement, any individual who's just going about their business and is, I guess, walking around with criminal proceeds in their pocket is now suddenly, can be convicted for unlicensed money transmission, even though they were never told that they were doing things that required a license. Like, I'm just walking down the street with a $100 bill. Oh yeah, I got it from a cocaine dealer. I mean, that's nuts. And frankly, if you're knowingly walking around with money from a cocaine dealer, you charge that person with money laundering, which the jury in this case actually was unable to reach a verdict on because the facts aren't there. You don't charge them with unlicensed conduct unless they're actually the kind of business that a regulator, either state or federal, asks to license. And oops, oh, well, the federal government actually said that these people don't need to license. So I guess we need to invent some brand new crazy theory of the law to charge these people in the Southern District of New York. And that's what they did.
And it to be specific about the way that this seems crazy, it seems like a certain kind of double jeopardy, right? If there is a charge for handling known criminal proceeds, and a different charge over in a totally different part of the criminal code for money laundering, which is effectively the same thing. I mean, that's how it struck me. Does anybody? I don't know how. Kind of with this crowd, it might not be necessary, but would either of you care to talk through this question of control of user funds, and also of just kind of the concept of transmission, right? Because another thing about Tornado Cash that struck me in this context is it is very specifically designed not to transmit to another person, which I think is interesting in this light. But do we want to do just a quick crash course on Tornado Cash?
Yeah, so real briefly, the way Tornado Cash was designed is that there's these immutable smart contracts on Ethereum where you can park some of your Ether or USDC. They accepted a couple different things. And it goes into a zero knowledge proof. And when you take it out using this special secret message that you get from the smart contract, when you take it out later, so yeah, you're not really sending it to someone else. You are putting it in and taking it out. Only you can remove that using the secret key. And the visibility on chain, it's impossible for a third party to sort of disambiguate your withdrawal from anyone else's withdrawal from that same smart contract, but you're the only person that can withdraw your funds. So in a very real way, like the metaphysics here, like we always have to make comparisons to the physical world. This is not like giving your money to Western Union and then Western Union putting your money in another place in the world and allowing like your aunt to withdraw it in the Philippines because you're doing remittance. This is more like I had money in my wallet, which is sitting on my dining room table, and I took it out of there and I put it in my safe, which is sitting in my bedroom, and I just moved money, all within accounts that I fully control, all within technologies, if you will, not accounts that no third party actually has any control over. That is, I'm not exaggerating. That is exactly how Tornado Cash worked, right? And so there's no moment where Roman Storm, there's not even a moment where, and there are some more complicated facts here. Like, yes, there was a torn token DAO that controlled some ancillary aspects of other smart contracts that are not the ones that your money gets stored. And there's some facts here that might be used to confuse a jury. And I wasn't in the courthouse, so I don't know how those facts were presented or if they were. But even the most like Byzantine parts of the Tornado Cash protocol, even the relayers, and we don't need to get into what a relayer is, even the relayers never had the independent ability to move your funds. You, throughout the entire process of Tornado Cash, have full control and sovereignty over your money. And there's no third party that can move it for you or fail to move it or move it to somewhere else or decide, this is money laundering, so I'm going to stop it. Like, there was no way for Roman to do anything about people using his tools for bad things. And he had no obligation to do anything about it. So this notion that he should be charged with unlicensed money transmission is is way off base. And then to give a little bit more background on the underlying law of control, as Amanda mentioned, and she's 100% right, FinCEN in 2019 wrote comprehensive guidance, and they are the money transmission regulator. They wrote comprehensive guidance on who, in their opinion, is a money transmitter. And they said people who are money transmitters are hosted wallet providers who have total independent control of customer funds. And they even got into things like privacy tech. They said there's a difference between an anonymizing service provider, like a custodial mixer, like send your Bitcoin to my address and I'll mix it with some other Bitcoin and send it back to you, and an anonymizing software provider, which is somebody who just provides other people tools for privacy, like the Samurai wallet, like the Tornado Cash smart contracts. And in making those distinctions, it's not because they were sweeping all of them into their guidance as money transmitters. They made those careful distinctions to give people clarity that you're not going to be treated as a money transmitter if all you're doing is publishing anonymizing software. And people relied on that guidance. I know several lawyers in private practice who gave their DeFi tech clients advice based on that guidance and said, you have to worry about Gary Gensler and the securities laws if you're issuing a token, but as long as your thing's non-custodial, you shouldn't have to worry about unlicensed money transmission. And so we have a massive due process issue here, and that's one of the things that I hope comes up in Roman's appeal. If the regulator gave you contradictory readings of the law to what the prosecutors ultimately prosecuted for, can you really be, were you really informed as to what your obligations were so that you could tailor your conduct to avoid criminality? Absolutely not. And the due process clause of our Constitution requires that kind of legal clarity before we throw people in jail, as it should.
Yeah, and if I can jump in here, I think that in that context, it was very interesting to hear Judge Fila. Sorry, I'm getting messages. Okay, sorry. It was Judge Fila today in court after the jury rendered its verdict. In the context of discussions of the decision to leave Roman on his own recognizance, she said in open court that the charge, the MTB charge that was convicted, was very ripe for challenge and appeal. So I thought that was extremely interesting to hear the judge say that after the conviction, with press present and et cetera.
Well, yeah, I think that speaks to the fact that she knows how hard people fought, obviously Roman leading the charge and everybody else in the industry on how this interpretation would come out in court. And I would also just say in the motion to remand context, I was really surprised and disappointed the moving to remand Roman after he has shown up to every single court date, has never missed a single thing that has been asked of him, has not violated his conditions of release at all. And they're trying to put him in jail while awaiting sentencing. And I just think it speaks to their broader bias in this case and the way that they have seen it. When their argument is he is a potential flight risk because he has access to money and because he, wasn't born here. Like it just speaks to their overall attitude throughout this case. But luckily, Judge Fela, did not buy that and said that she did not think that he was a flight risk, and signaled that there are a lot of issues that are going to be read for review.
So you both just touched a little bit on FinCEN guidance as well as on the Samurai Wallet case. If I remember correctly, SDNY prosecutors contacted FinCEN before bringing charges against the Samurai Wallet developers, which was revealed in the Samurai Wallet case. And FinCEN had told prosecutors that they, in their opinion, did not believe that Samurai Wallet would qualify as a money transmitter. So given everything that we have the guidance from 2019, we have these statements made by FinCEN officials on Samurai Wallet, which I believe also came up in the Roman Storm trial, pre-trial hearings. I think it would be interesting to touch on why wasn't FinCEN allowed to be brought up. And I think that this is where we're touching on the Blanche memo that came out in April, which I think both of you kind of sounded the alarm on a little bit while everybody else was celebrating. that it had very favorable language to cryptocurrency mixers, and in particular, saying that they should not be prosecuted based on licensing violations. I think both of you both stated that maybe there's something to be a little bit more careful with. And I think, in my understanding, this is ultimately the reason why FinCEN wasn't allowed to be brought into Roman Storm's case, because the licensing violation wasn't there anymore. So maybe either of you could touch on that as well.
So the Blanche memo, Deputy Attorney General Blanche of the Trump administration, this is a few months ago, published a memo whose I think it was in the title. Was either in the title or in the first paragraph, and it became sort of the way we think about the memo, saying that they want to end regulation by prosecution. And on its face, that sounds exactly on target, because you couldn't think of a better example of regulation by prosecution than a situation where a developer was told by the regulator they didn't need a license, but was then prosecuted for unlicensed conduct. The prosecutors are trying to regulate while the regulators are trying to set good law. And it was our hope that the Trump administration would weigh in here. And the Deputy Attorney General's memo, it had the right title. Unfortunately, it equivocates a little bit in the actual legal meat of the memo and doesn't maybe go far enough. And I think there's some hermeneutics or some sort of like straining at the text to figure out where things went awry. And I can't pinpoint blame. I can't pinpoint blame on the Trump administration or the Deputy Attorney General or the DOJ, as in Maine DOJ, or the Southern District of New York, as in a subdivision of the DOJ. And the DOJ is notoriously independent from the president because, in theory, they also are there to investigate the president sometimes. So there's a lot of sort of like, no one knows where the buck stops and why, ostensibly, with Trump wanting America to be the pro-crypto capital of the world, we still ended up with Roman Storm having to fight it out and ultimately get a guilty verdict on this charge. But I do think that the Southern District of New York, the prosecutors, I think they dropped the failure to register count in response to the Blanche memo, as a way of harmonizing the Southern District's prosecutions with this new Maine Justice memo. And I think I even recall that acting prosecutor Jay Clayton, who was formerly at the SEC, wrote in a letter that because of this memo, we are not pursuing this charge further. Now, I wouldn't turn that into, and Lola, I don't mean to accuse you of conspiracy. I think your theory is possibly true, but personally, I don't think that was a deliberate attempt to exclude FinCEN evidence, like things like the past communications. I think it was a insufficient but good faith effort to reduce the charges against Roman. I just wish that Trump had sort of gone in and said, this needs to end. Granted, that does violate a lot of norms and rules we have about the independence of the DOJ from the president. Of course, they did violate a lot of those norms and rules when they pressured the Southern District of New York to end the Eric Adams prosecution. So there's a lot of complex political machinations here, and I won't pretend to be an expert in the complicated sort of ugliness that is state and local politics with respect to the federal DOJ. But I do think that when they're no longer going to bring that failure to register charge because the Deputy Attorney General's memo says we're not going to charge people for mere failure to register. We're going to charge actual narco traffickers. They're saying, all right, we won't bring that charge anymore. Arguably, the other charge, because it involves knowledge and intent to transmit criminal funds, could still stick under some tortured reading of ending prosecution or regulation by prosecution. And then when it goes to a jury, the jury can't hear about whether or not they registered, because that's a legal question. And that's a legal question that actually isn't being tried anymore because they dropped that count. And so
Right.
it's sort of bad luck, I think, with respect to that. But important fundamentally for the appeal, which is where we can talk about legal questions, because in the US system, jurors are fact finders and the judge is sort of the legal fact finder or the interpreter of the law. So when we appeal up to the Court of Appeals, we can reopen those legal questions. That won't be out of bounds anymore. And with good, appellate counsel and with a strong fight, I think we can make it clear that what's gone wrong here is a legal issue. Like these charges should have never been brought to begin with on the law, let alone any facts that a jury finds as to whether or not they registered or what their state of mind was, that kind of thing.
Right. Maybe I should rephrase my question, because what I meant to ask was whether dropping the federal registration charge was what led to FinCEN not being allowed to be brought up at trial. Because I'm
Yeah, so-
unclear
Yeah,
on
I
that.
can speak to
Oh,
that.
go ahead. Sorry, David.
Or I'll let Amanda go. Well, I can give my very brief version, and then you can probably go into more depth. Just from being there, witnessing the procedure, there was a lot of. I mean, this entire trial was really characterized by a lot of wrangling over what everybody was allowed to say at a very granular level and what words were going to be heard by the jury. And FinCEN was part of a larger discussion about how to present evidence where, for example, there were chats of Roman and the other team members discussing compliance. And there was a lot of back and forth between the defense and the prosecution over whether the jury might interpret those discussions of compliance in light of this registration requirement, for example, which, as Peter said, was not being tried. And so that was, I think, one aspect of concerns over discussion of things like FinCEN. But Amanda, you might have more there.
Yeah, so sorry, I'm hoping that you can hear me.
You're definitely cutting in and out for me, at least.
Sorry.
I think we might.
How about now?
Yeah, that's better.
Okay, great. So there were motions in limine about whether FinCEN could be mentioned in this trial. And that means that the DOJ moved to keep out any reference to FinCEN throughout the trial, and the defense fought it, to my memory. And the reason for that was the government, their position was that there is no relevance to the 2019 FinCEN guidance if defense was not going to be able to show that Roman Storm had that guidance in his mind at the time that he was writing the protocol. And they had a very narrow view of what would be relevant in the trial. So the defense, obviously at that point, was not going to say, hey, Roman's going to take the stand and tell you what's in his mind at the time that he's writing the protocol and tell you that he relied on this FinCEN guidance in believing that he was not operating a money services business. So the defense had to instead argue that it was relevant because everyone in the industry had read that guidance and everyone in the industry relied on it in understanding what a money services business was. Judge Fela unfortunately did not agree with the defense in that and decided to limit how much FinCEN guidance could be mentioned at trial because of an evidentiary issue, that relevance issue. If Roman had testified, there is a world in which he would have been able to say, hey, I actually relied on that guidance, I got legal counsel on that guidance, and I still wrote this code. And then there would have been an open door to putting in more evidence on the guidance. But obviously there's rules of evidence here that limit what kind of testimony can come in and what topics can be testified about. So this really was an evidentiary issue that was ruled on before trial even started.
Okay, so that might be, I might have slightly misinterpreted in looping FinCEN in with the broader discussion of compliance discussions. I don't know if we want to shift slightly, but at some point I do want to make sure that we talk about the two charges where there was no unanimous decision by the jury and therefore a mistrial. I guess one thing that I think is, Peter did mention earlier, was this question of intent that became very, very important as the trial wore on. A lot of the evidence that was presented by the prosecution was things like chats among the co-founders that, they attempted to put forward could be interpreted as knowledge that what they were doing was illegal. For, I think, probably the most notorious piece of evidence in the trial was a T-shirt with an image of a washing machine that was worn by the Tornado Cash team, I believe, at the 2019 ETH Boston hackathon. And that was taken as sort of foreknowledge of their criminal intent. Can anybody speak to that sort of the maybe let's start with just like the general role of that question of intent, because, you know, the reason it matters here is that we know that no evidence was presented that Roman Storm or anybody else, for example, spoke with North Korean hackers to try and plan their use of Tornado Cash to launder funds. So that's not where the conspiracy charge lies. The conspiracy charge lies with the idea that Pertsev, Storm, and Simonov together engaged in a conspiracy with the intent and foreknowledge of enabling criminal money laundering. So that's kind of the theory of that charge. And obviously the jury did not arrive at a unanimous take on that. So do either of you, Amanda or Peter, have a sense of, or have some commentary on that aspect of the case?
So the question of intent or mens rea in general is really more relevant to the money laundering allegation than it is to the 1960 allegation. So
Yes, sorry, I should have clarified. This is for
no,
1 and
that's
3.
okay.
Yeah.
It's honestly, it's confusing because 1960 also does talk about knowledge, right? So there is a level of mens rea required by 1960, but there's a higher level of mens rea, mental state, required by a money laundering charge. You have to actually intentionally facilitate the transfer of criminal proceeds, or like know that knowingly facilitate the transfer of criminal proceeds. There's a higher level required for the government to show. So in that case, in this case, the government was trying to say that because Roman had this T-shirt on, which, you know, according to them, implied that he was creating a thing that could be used for money laundering. According to them, that was supposed to satisfy their burden on proving that he knowingly facilitated the transfer of criminal proceeds for money laundering. But there are other elements the government must prove in addition to that. And again, this is a conspiracy charge, which means that they only needed to show an agreement to launder money and one step in furtherance of it. So I'm sure that the jury was a little confused, which may be one of the reasons why the jury hung on this verdict. But it actually would have been sufficient if the government showed that Roman agreed with another person to launder money and they took one step to do so. But clearly the jury did not think that the government had met their burden in even showing that Roman agreed with one other person to do that.
And
the
only thing I was
go ahead, Peter.
The only thing I was going to add is that it's an incredibly dangerous precedent to set, and I'm glad we've avoided it with the hung jury. That sort of like knowing that your tools that you publish as open source software or to the blockchain or to a website that's on the public internet, just the vague knowledge that people will misuse those tools is sort of the mens rea required to charge someone with money laundering. That would be extraordinarily dangerous. And I'm glad that the burden is a little higher, and then it was difficult for the jury to find that the burden was met by the prosecution. Because otherwise we're in a world of pain wherein, you know, Linus Torvald probably could imagine that Linux, the software he developed, would eventually be used by Iran to power centrifuges and control them to make nuclear weapons, right? Like that's how open source software works. We may not like it, but we don't want to ban or effectively criminalize the release of open source software if you can imagine your software being used for anything bad. The other point I want to make is, to Amanda's point, that the mens rea is a little different in the unlicensed money transmission charge, this like simple knowledge requirement, versus the money laundering charge. There's some sense to that in the law. If you are a regulated entity like an actual licensed money transmitter, you probably should have a higher burden as far as like not letting the stuff you control, the money you control for other people, end up hiding other people's crimes. Like Credit Suisse probably should have been more responsible with the Russian oligarch money that it was effectively laundering for the Russian oligarchs. They should have the prosecution should have a lower burden to prove that they should have known, or they did know, and they did something wrong then. But this goes back to what needs to be a requirement of an unlicensed money transmission prosecution is the first step of saying, you are a money transmitter. Therefore, you are a financial institution of a sort, either federally registered or state chartered, and therefore there is a higher burden for you with respect to handling other people's money. But if you don't handle other people's money, if you're not a money transmitter, then that low burden for the prosecution to reach, which was enough for the jury to find, shouldn't apply to you. That's like holding every human being on earth to the same standard we'd set up for Credit Suisse as far as preventing other crimes from happening. You don't have a duty to rescue in this country. And you definitely don't have a duty to rescue or to prevent crimes merely because you did the cool thing of inventing new software and publishing it online.
Yeah. Or tools in general, I think, is the other thing to keep in mind here is, this could require like anticipatory foreknowledge of any possible negative use of any tool that anybody invented ever. So yes, again, like I think some people were definitely disappointed by this verdict, but I found the two hanging conviction charges pretty nice result, because they do imply that the jury thought about this question. And I also should say that at the defense at trial presented a lot of evidence from kind of Storm and company's interactions with the Ethereum community as they explored the ideas that would become Tornado Cash. So, for example, the hackathon that they won in Boston, messages from Vitalik to the effect that building privacy on Ethereum would be a valuable project. And what I read, and admittedly, this is conjecture. I tried to talk to some jurors after the trial, but wasn't able to catch any of them. But what I take from that is that they, saw that there was a real legitimate use case and reason for this to exist for non-criminal uses, and that I think we can sort of infer lightly that they gave Storm and company credit that was a major, if not the overriding element of their intention in building it. So just to call that out, that like that context around their motives, I believe did play a role in him getting not convicted on these charges.
Yeah, and to that point, I was actually happy to see it was Eleanor Terrett who reported that she got a quote from Roman towards the end, and said that he was actually not feeling that down. He said something like, "It's a big win. The 1960 charge is bullshit. And we're going to fight it all the way." Like I kind of agree. I think juries actually aren't always that bad in the U.S. And I would have preferred a not guilty verdict, but a hung jury, because enough of them stand up and say, "I don't see the proof here for these things." On those other charges, the sanctions charge and the money laundering charge, that's great. And the jury was they were fenced in on the 1960 charge because they weren't given the opportunity to really make the decision on the part that's most relevant to that charge, which is the definition of money transmission, and whether Roman, was cognizant of that definition and relied on bad legal counsel. But fortunately, on appeal, we can reopen those legal questions, and hopefully we can win that on appeal. So.
Yeah, and I definitely want to call attention to your comments about the jury, because I've not watched a ton of trials, but I've watched a few at this point, and I've been really impressed, frankly, by the seriousness and quality of the juries in a lot of these cases. And in this case, it was very evident, because over the course of just about 3 full days of deliberation, the jury was sending notes back and forth to the judge, asking for exhibits, asking some very pointed questions about issues, including, for example, venue. It was obvious just from watching those notes come out that the jury was thinking very hard about the very nuanced questions that they were being asked. And I think that, it's a double-edged sword. We were talking about how aggressive SDNY can be in trying to get venue for these financial cases. One of the, benefits, I guess, of that on net, I'm a bit of a New York chauvinist myself, but these are juries who, they're around finance because that's what is happening in New York. And so they're at least tuned into some of the, complexities here in a way that I would, lightly submit not every average jury across the U.S. would be.
Yeah, I fully agree with that, David. I would just add that, it is actually very hard to be the holdout juror that doesn't agree with the rest of the team, right? And we don't know what the actual breakdown was of people who wanted to vote guilty or not guilty in order to come to this, the decision to tell the court that they were not going to be unanimous. So I think that it does speak to the conviction that the people who were not going to agree held, that they were going to say, like, we are going to keep with our not guilty stance, and there were other people who disagreed with them. But the judge did do an Allen charge, which means the judge instructed the jury to keep deliberating after the first time they said they couldn't agree, and they came back and said, we still can't agree. So I do think that that shows that there was really careful consideration done. And, the government did not meet their burden. They were not convincing in order to get all 12 to agree with them in the way they've presented the charges.
One other topic that we could tackle is, and many of us have heard Roman speak and have our own impressions of him. He did not ultimately choose to testify in his own defense. That is very frequently given as advice to criminal defendants. And one thing that was pointed out to me on this question was that if he had chosen to testify, the cross-examination would have involved him having to explain every kind of off-color comment that he made in those chats. Well, I guess, do y'all have thoughts on Roman not taking the stand?
Yeah, I mean, as you said, it is common counsel that a defendant should not take the stand. They are subject to cross-examination on every statement in the case that they are on, every chat, every email in which their name appears. They can be cross-examined about anything they've done in the past if there's a history of criminal convictions, which I'm not saying there was here, but it just shows you the breadth of what a criminal defendant can be cross-examined about. Also, it becomes a merit test of whether the jury thinks the defendant is lying about anything. Basically, if a defendant testifies and the jury judges their character based on what they're seeing on the stand and says, he doesn't seem like somebody who's telling the truth on this one thing, they'll take it to mean that a defendant is not telling the truth on all things. So it's just a very risky proposition. And of course, I think Roman presents very well and would have done a great job if he decided to take the stand in his defense. But I think that ultimately it was the smart move for him not to do that and not to open up the scope of every statement that could be taken out of context and be asked to him on cross.
Yeah, I was just going to agree that it was probably the smart move given the rules of evidence and cross-examination. And, jurors are often then instructed, and the prosecution is definitely forbidden from, arguing that his failure to take the stand somehow indicates guilt or anything like that. So this is all very, very typical for a criminal prosecution. As much as I would have loved to see Roman on the stand, actually, because I think he would have done great, but it opens up a whole can of worms that could have been worse.
I'll just quickly note here for people in the audience, we are going to have a Q&A as we sort of get towards the end here. So do think about any questions that you might have for our panelists or for me about the proceedings. And in a few minutes here, we'll open it up and take questions in hands. Amanda or Peter, you were sort of watching from afar for the most part and seeing the reports coming out. Were there elements of the trial or moments that you think are worth highlighting as we kind of look back on it now that it's at long last over?
I mean, I think I hinted at this earlier in my response. I was a lot more involved moment to moment back when the whole thing was at the motion stage, the pretrial motion stage, because that's where a lot of those legal questions about what is money transmission and is FinCEN's guidance sort of does it fully overlap with the criminal code, or is there a difference between criminal unlicensed money transmission and the regulatory obligations to license? And so, those issues were largely resolved last winter. And I tweeted earlier, that's why I was so angry for a big part of last winter, because I thought they were resolved in completely the wrong way. And it's made me sort of eager to see where the appeal goes next. It's also made sort of underscore.
And you could argue that a substantial portion of the trial really was decided in those motions. They were so
especially
consequential.
vis-a-vis this one charge where Roman was found guilty, because as I said, the jury had very little, freedom of motion once you've decided that money transmission is effectively facilitating any movement of tokens on chain. You've kind of given away the defendant's best defense and the best facts to find for the defendant, which is that actually they didn't control anyone's money, which is what the definition of money transmission should be. And so for Coin Center, and our mission is to work, to defend individuals to some extent, to the extent we can help with an amicus brief. Our main mission is to just work for good policy for everyone to benefit from. And this is a disaster for us, that motion back in the winter, because suddenly all this, advice from this guidance from FinCEN and this advice that lawyers have been giving in this space and all the work Coin Center has been doing, socializing that good guidance with members of Congress and with other agencies, saying that this should be a model for how we treat developers in this space, is suddenly put into question. And it's our core mission to make sure that you feel safe writing software in the United States. You don't feel the need to go overseas to do that kind of thing. So I would just, point to that and say, it's my hope that we can appeal this. It's my hope that Michael Llewellyn, who's bringing a civil lawsuit in Fort Worth, Texas, that Coin Center is supporting, can force better clarity on the legal matters in that court, which could then sort of bring some change in legal precedent from another circuit. And it's also my hope that Congress, and we haven't covered next steps for Congress and things like this, passes the Blockchain Regulatory Certainty Act, which got attached to the Clarity Market Structure bill that passed the House with an overwhelming bipartisan majority, because the Blockchain Regulatory Certainty Act, which is halfway to law, we just need to get through the Senate, and then the president has said he'll sign it, would clearly say in law that the DOJ can't continue to ignore, like they're ignoring the FinCEN guidance, that if you are a non-controlling blockchain developer, you don't have total independent control of customer funds, you are not engaged in money transmission and should not be liable for unlicensed money transmission. It's like a really good, simple statutory drafting exercise to clamp the brakes on this abusive prosecutions from the Southern District of New York. And we owe a debt of gratitude to Representative Majority Whip Tom Emmer and Representative Richie Torres, and also recently joined by Gottheimer and Huizenga, who introduced that piece of legislation. It's bipartisan, strong Democrats and Republicans on both sides. People just want this to be over, so that software developers can actually locate themselves here in this country, take advantage of their First Amendment freedoms, and build good tech. So there'll be a moment in a couple of months where it might be important to call your senator, because they're going to need to pass clarity in the Senate next, and we want the BRCA attached to it. So stay tuned for that. Sadly, it will be too late for the Samurai devs who took a plea, and for Roman, because the law won't be retroactive. But hopefully he'll win on appeal. So, yeah.
Amanda?
David, just going back, David, going back to your original question, because I agree with Peter that the motion practice was obviously a very critical point in this trial. I think, as you covered and Lola covered and Tay covered and a lot of other people who are watching this trial minute by minute, the government made many, many missteps here. Right, the very first witness they called, which was supposedly a victim, she is a victim, to be clear. It was supposedly that the funds that were hacked from her account and sent to someone else, they claim that those funds were eventually sent to Tornado Cash, and that was disproven by multiple people, including Tay and Zach XBT. And that really, I assume, shook the foundation of the jury's faith in what the DOJ was presenting to them, because if they could not put up a witness who they could show whose funds went to Tornado Cash, that does call into question their ability to understand what's going on here more generally. I think there was a bit of a battle of the experts, as you all covered, right? There were some experts put in by the DOJ that did not seem to be well versed in blockchain tracing, did not seem to be well versed in how all of this tech works at all. And the defense had the opportunity to put up their expert and try to beat some of that back. It's obviously difficult to do that when you go second, right? The government gets to put their whole case on multiple witnesses, and then they rest, and then it's the defense turn to put up witnesses. But by that point, the jury has already heard a ton of evidence from the government. So I think there are many appealable issues here, dating back to the motions that Peter was talking about and continuing through trial. every single time an attorney says objection during a trial, that is preserving an issue for appeal, meaning the judge makes the decision about whether something can come in or not, and defense can appeal and say that she made a mistake, Judge Fela should have let this in or not let this in. So I do expect that Roman will appeal the 1960 conviction. And as Peter said, there is more that we can do here. Obviously, we don't want the DOJ to choose to retry the 2 charges on which the jury hung. And we are also very supportive of the Blockchain Regulatory Certainty Act. I would say on top of that, we really need a fix to Section 1960. We need a fix that amends 1960 so that it cannot be misinterpreted the way that it was by the DOJ in this case. And we are proposing that exact fix in market structure to also get attached and protect developers. So there are things that we can do going forward, but we are support Roman as he appeals the 1960 conviction no matter what.
Yeah, and if I could just really very quickly, kind of as a teaser to get everybody to go and hopefully read some of our coverage, both Amanda and Peter touched on this witness who had been victim of a pig butchering scam. She was the very first victim, or very first witness put forward by the prosecution. And essentially, now this, I would welcome any corrections to this version of events, but my understanding sort of implicitly was that the government had rested her relevance, her connection to Tornado Cash, largely on a report that she had received from a tracing and recovery firm called Payback, which does not seem to have necessarily been all that legitimate, at the very least in its tracing. By that time, they had already tasked their FBI blockchain tracer, a witness named Joseph DeCapua, who seemed frankly fairly competent, but they had already given him his tasks, which were to trace the funds from various hacks to Tornado Cash. So we actually didn't confirm and wasn't able to confirm that this previous witness's testimony had, or money had actually gone to Tornado Cash. At this point, give or take by a few days, the defense actually raised the possibility of a mistrial in proceedings in court, because you now had a witness who had claimed that Tornado Cash had had some of her money, but there was no actual supporting evidence for that claim that was valid. Now, after that, they then had a second tracing witness, quote unquote, but he wasn't really a tracing witness. He was an IRS accountant who I believe had mostly been tasked with tracing the money from the sale of Torn tokens that were essentially the investment vehicle for the Tornado Cash founders, or the way that they essentially cashed out. I hate that language, but it is what it is. So this IRS agent then did a very non-conventional form of tracing, to say the least, called first in, first out, or FIFO, to claim that it showed funds flowing from Han Feng Lin's hacked stolen funds to Tornado Cash. However, even under cross-examination, immediately after presenting this evidence, the defense counsel was able to get him to essentially admit that his analysis did not actually prove that Katie Lin's funds wound up in Tornado Cash in any degree. So it was very much a comedy of errors, and I think that there definitely would. I mean, I'm not a lawyer again, but I feel like there would have been valid grounds for a mistrial simply at that point, because you had this very sympathetic witness claiming something that doesn't seem to have actually been proven true in the course of the trial. You know, I would definitely encourage people to go back and read about that section. It definitely shows the fallibility of the government. I would love to have people, if you have questions, you want to start raising your hands, and then we can bring you up. But Amanda and Peter, I don't know how much exposure you guys have to jury trials, but how much can we infer from the fact that we have these split decisions? You know, what is it? What can we take away from just the jury's inability to agree in this criminal context?
I don't have a lot to say because I'm not an expert, so I'll just make brief remarks and leave it to Amanda, who has got more trial experience. But it makes me proud to be an American. Alexis de Tocqueville, who wrote Democracy in America, you know, he's a French aristocrat who visited America in the 1800s to like report on how it's going to Europe, was like, the big things that are going to prevent America from falling into tyranny are two things: the practice of lawyers and the practice of trial by jury. And this notion that we have to reduce things to simple facts that our peers as fellow Americans can understand, and if we fail to do that, we don't convict our fellow man. That's really smart. And it's not always perfect, but I wish oh man, I would eat up a recording of these jury negotiations. And obviously that's not ever made public, but I would love to know what it was. And in my head, it's just obvious that the government made a lot of missteps, was hyper aggressive in all the wrong ways, basically tried to prejudice the jury against Roman by bringing up this sympathetic victim who actually had nothing to do with Roman's conduct. And then, yeah, if I was a juror, I'd be like, let's go. We're not guilty on all counts. You can tell me I got to negotiate with my fellow jurors a little bit longer, but I'm not changing my mind. And so I want to meet those jurors. I'll buy them a drink. Maybe that's jury influence peddling, and I shouldn't do that, but I would totally buy those guys a drink.
No, after the fact, it's all fair game, actually.
Nice.
Amanda, you want to comment on that?
Sure, yeah. So, I mean, the juries statistically convict more than they don't convict, right? It is very difficult to sit there and be told these facts for the first time and pick apart technical explanations, legal explanations, and follow all of it. And many of them don't even take notes, right? So they're literally just listening for days on end. And, imagine like the attention that it takes to listen to evidence uninterrupted for that long. But what I think happened here, and what I think this reflects, is that juries often try to compromise. Like, unless it is a slam dunk, there's no chance that this person did it, and that is really rare. That is like a movie moment. Doesn't really happen that often, and nor should it, right? Like, when the government indicts a person, it should be the case that they have enough evidence to prove their burden before they even get to trial. So it should be the case that the government shows up and there's some legitimacy to these charges before they even open their mouths. But a jury will think to themselves, you know what, like, let me convict on a lesser charge. So that's why you'll see sometimes when there's lesser included charges, a jury will convict on the lesser charge, but not the top charge, because they'll be like, well, we're not totally sure about this and we don't want them to get a long sentence, so we'll convict on this lesser thing. And I think what may have happened here is the jury viewed the 1960 charge as somehow lesser than money laundering or sanctions evasion, which sounds like big, scary words, right? And yes, they're all three conspiracy charges, and there is a limited sentence for each of them, right? A 1960 charge under a 371 conspiracy results in a maximum of a 5-year prison sentence. But juries can't even consider that. They can't consider what the sentence might be. But they might have guessed, and they might have said to themselves, this sounds technical. This doesn't sound as serious as money laundering or sanctions evasion, so let's convict on that. But like I said, I think it really speaks volumes that the holdouts remained convicted throughout those proceedings, because it is a pressure cooker in that room when everybody is trying to come to a decision and the judge is telling you that you have to come to a decision.
Thanks, Amanda. Okay, I'm going to start bringing up questions. I'm going to start with OK Hot NFT. I think you were first. Let me give you the mic. There you go. Well, okay, mate, gotcha. Maybe I'll go ahead and move on to David Hoffman. David, you should have the mic. David, there you go.
Hi there. Hey, first, thanks, David, just for all of your reporting, and I've been enjoying this space so far. I think probably speaking from the naive perspective, which I think I probably represent from anyone who's not a lawyer or who hasn't been following this case just very intimately, there's just like a lot of stuff going on, and there's just like a lot of bureaucracy and a lot of rules, and some rules apply in this scenario. I want to kind of zoom out and kind of ask more of a vibe that I want you guys to check on. My understanding, my kind of takeaway right now is that I'm very happy that it seems to be that Roman is happy and he's able to walk free as a software developer, as a man who was removed from the charges of anything related to money laundering. He's getting the smaller charge, and this smaller charge, importantly, is something that all of you guys are saying doesn't make sense and has like loss of surface area for us as an industry to leverage and turn into a win. And so like I'm in debate with Ryan, my partner, about like whether we should be taking a glass half empty or glass half full perspective. My perspective is that the glass half full perspective is objectively the right one, because even though there's some bullshit that happened that we should be upset about, we have the ability to flip that in our favor with pressure, support from Coin Center, support from the legal minds in the crypto industry to flip this whole like FinCEN thing part of this ruling that I think we all disagree with, and flip it in our favor in the future. And so I see a path where there is just a complete victory here, and I want anyone to like check me in my like misunderstanding or just naivete about how this is all working.
So some quick cautions, because it's a hung jury instead of a not guilty verdict in the other two counts, and those are sanctions evasion, conspiracy to sanctions evasion, and conspiracy to money laundering, they could re-prosecute. And maybe they've learned from some of their mistakes here, and with a new trial for those two counts, we're still back where we were. So that's a real danger. The other thing is, as far as the appeal, I still wouldn't want to be in Roman's shoes. I'm glad he's in good spirits. I'm glad he's out there saying the 1960 charge is bullshit, because I agree it was. But he's still going to have to fight it, and a lot of that's going to come down to what the principles of statutory interpretation and deference to regulatory interpretation, and the judge's beliefs as the interaction of the regulator's guidance with the criminal code, what they're going to think at the appellate level, where we're going to have judges who are going to weigh in. We can make really strong arguments, and I am like bullish that we will make incredibly strong arguments, but a lot of it's going to come down to the luck of the draw with like what judge they get on an appeal, and how well the briefs end up written, and how much support we can marshal as amicus briefs and as a community, just to sort of push the scales one way or the other. I'm also optimistic that we can open up other fronts, like Michael Llewellyn's lawsuit in Fort Worth, Texas, where we can make these same strong arguments about the law, and in a forum where they are more, they're better entertained by judges who are more skeptical of the overreach of prosecutors and of administrative bureaucracy. And I'm optimistic for the Blockchain Regulatory Certainty Act, which amazingly moved quite smoothly through the House, I think because everyone realizes this is just bad politics. Like, why are we going after privacy developers who are actually just building good tools for human dignity? And I hope we can repeat that with the Senate. And I hate to say this, but I'm going to say it, like, and maybe this will make Roman feel a little better. The fact that he was found guilty, I think, will underscore the importance of getting it right in the Senate. And so hopefully he'll be, innocent. He'll be not guilty on appeal, but also hopefully this current bad outcome for him will galvanize our ability to lobby for good policy in the Senate. And then it won't have been fully for naught, and that's what matters.
Yeah, I agree with that, Peter. I think Peter's right, and I do think that I just don't think it's easy to call it a win or not a win. I just think it's more nuanced than that. I it's really hard for me to think of this as a win for the space, given the verdict on 1960, which is so important to software development in general. But it is obviously a win that the jury was not convinced of the other two charges, and that the government did not meet their burden because this whole case was fundamentally flawed to begin with. And for Roman, there is limited, like I said, limited sentencing exposure here, because the maximum that he could face is 5 years versus, a much longer sentence on some of the other allegations. But it's just hard to feel like it's a win when the 1960 precedent is really concerning for software developers. But I'm glad for Roman that he was not remanded today, and he gets to go home and be with his daughter, and he's not going to be in jail for the foreseeable future. And we do have great arguments for appeal. And there is a path toward trying to undo some of this.
I guess a lot of my optimism comes down to the fact that, like, whether or not the 1960 precedent, how easily overturnable that is, and like, so like, say we get the bad outcome with the 1960, which is like looking what you guys are all talking about. Like, I guess my optimism comes from the fact that I have faith that, like, in the future we will be able to take care of that as an industry.
I mean, I wish that I felt optimistic about that. I mean, we will keep fighting for it, right? Like, I do think there are appealable issues here. It's just not often that convictions get overturned on appeal. So I hope that that's what happens. I hope that the Senate hears us and amends 1960 and the BRCA stays in market structure. Like, I am optimistic about those things. But I am like, as a former criminal defense lawyer, right? It is hard for me to feel optimistic for Roman since there is now a conviction. It is just harder to overturn that. But I think that there's a lot we can do. We can, tell the powers that be how we feel about this, the senators and the House and everybody who has a chance to change the law. And we also can make it clear to the administration that Roman's case mean like they should not retry the charges that the jury hung on, and if there's a chance for a pardon here, that he should be pardoned even on the 1960 charge.
I'll add just briefly also that the guilty verdict, while I think wrong and regrettable, underscores that there is a credible threat of enforcement for developers in this space. And that obviously is bad news for developers, but is good news for Michael Llewellyn's civil challenge in Fort Worth, Texas, because he's right now facing, the DOJ who he's suing is arguing for dismissal of his case, saying, well, he's just a good guy developer. He faces no credible threat of enforcement. But meanwhile, the same DOJ just, got a plea deal from one set of wallet developers and got a guilty verdict from another on their bad theory of the law. So I think it'll actually make civil challenges a little bit easier to bring, and it's important to bring civil challenges. That's how we like grope at a better understanding of the law in this country. That's highly court based when you can't get Congress to act.
So I
Thanks,
want
guys.
to make sure that we get to all of the questions that we have, which seem to be a lot. Eleanor, you want to add something to what was just said, or are you raising your hand for a question?
Raising my hand for a question, but if you want to go in a different direction, I can wait.
Maybe hold that thought because we have some other people here as well who've been waiting. I'd like to go to Nopara 73, if that's okay for you.
I want to express my appreciation for you guys because this could have gone very, very differently. The past 5 years, I've been watching centralized mixers being the operators of the centralized mixers being jailed left and right, and no one have ever even heard about them. And now they got to anonymity technology that's non-custodial. But even then, I don't think people even here have heard about the other Tornado Cash guy who got jailed in the Netherlands, right? So, but now we get to the US, and you guys are just doing a great job. And I have been very, very careful with my words regarding these topics, and I never talk, but obviously my life is is in danger by talking about this. But you guys just kind of mobilized me with your reporting. And anyway, I just wanted to say thank you. You guys are doing a great job covering this.
Thank you. We
Thank
really
you.
appreciate it. And it's
Cool.
it's a privilege. It's definitely a privilege.
Yeah, it's yeah. Cool. Yeah, maybe then we can jump to Eleanor because I think you wanted to add on what was said before.
Yeah, thank you for everybody who's on the call, and also to Amanda and Peter for taking the questions. But I just wanted to, so apologies if this was already addressed, but for the FinCEN guidance, because it wasn't allowed to be admitted at the district court level, or at least like a very small mention of it, is it allowed to come up in the appeals court? If so, if they do appeal, obviously.
So the record on appeal is limited to the record at trial in this case. So only the evidence that came in at trial will be able to be used on the appeal.
Gotcha.
But
Okay.
Amanda, maybe I'm wrong about this, so please catch me if I'm wrong. When we're reinvestigating the legal theories for the motion to dismiss, and we're asking, what is the correct statutory interpretation of money transmission? What is the correct regulatory interpretation of money transmission, which is a which is or should be read as a predicate to the criminal charge, the government's records on as to what the regulator has said about money transmission are relevant to those legal questions. Surely that will come up again. We're not going to reopen the facts. The facts have been found by the jury and can't be changed. But the legal questions is where this thing went off the rails. And, the legal questions are highly relevant to, do we give deference to the regulator? Do we have a due process defense for Roman because he relied on statements from the regulator? And maybe so I'm not an expert at trial, but I feel like that has got to be relevant.
Amanda, could the appeals court
Yeah.
rule that was like an error of law by the court not allowing it to be admitted in the first place? Is that a possibility?
Yes, Peter's exactly right that all the legal arguments that were preserved for appeal can be revisited. So anytime there was an objection or a motion made, that's a legal issue that can be re-raised on appeal, and the appeals court starts de novo on that, meaning it gets to review it as if it's for the first time. It's just that the findings of fact cannot be disturbed, meaning you can't use evidence that was not ever presented at trial on appeal. You're limited to the facts that the jury heard and the judge had before them.
Right. So here's the way to think about it. Instead of the appeal court saying, the jury was wrong, Roman did know about the FinCEN guidance, and that's a fact, and therefore relied upon it, and therefore it doesn't have a culpable mental state. That would be inappropriate, because then you're overturning the fact finding of the jury. But if the appeal court is instead saying, the judge didn't tee this up for the jury correctly at all. The jury didn't just need to find that he had the right or wrong mental state. The jury needed to find whether he was doing money transmission. And the judge said that money transmission was this broad category of like ancillary facilitating like activities of like moving money on chain. The actual law is, did he have control over customer funds? And so they were wrong when they presented the jury the question, did he have control of customer funds, or failed to present that question? And therefore, we will overturn that particular ruling, not overturning the facts of the jury, but overturning what the legal question that needed to be reached was. And to answer that legal question, you need to decide de novo, as Amanda said, what does money transmission mean legally? And I think there's many reasons to bring in the money transmitting regulator's interpretation of that term when you're de novo reviewing what that term means legally.
Do we have another question to bring up, Lola?
Yeah, I think we have a couple. I think next was NFT Herder. Okay, Hotshot, if you want to go ahead.
Hey, thank you. First off, thank you all for covering this. I'm sure we all appreciate your hard work. My question is, how does this verdict, how does it may impact the developers currently working on privacy or DeFi? And do you think this outcome discourages further innovation in the space?
I mean, 100% discourages innovation and is a threat to developers. And that's why when the case was first brought, and I happen to have known Michael Llewellyn for a while, when he told me about the software he was already planning on working on and publishing, and said he'd be willing to sue to make sure he doesn't end up on the wrong side of a prosecution before publishing it, I said, yeah, that's a great idea. You should do that. It's your right to publish that software, and you face a very real and credible threat of enforcement for something that you really shouldn't ever be held culpable for. And so I think Michael Llewellyn's position is not that dissimilar than a lot of people in the space. To give a couple facts from his civil challenge, he wants to publish this protocol called Pharos. It's basically like GoFundMe, but decentralized. So, you could set causes like funding different public goods, and the funding only goes to the recipient if you reach the stated goal, like $1 million, but all of it's done on chain without trust, and all of it's done privately using technology similar to Tornado Cash. So it's a good tool. It's a tool that Coin Center would love to use to do fundraising for our charitable mission of advocating for, sane crypto policy in the US. And it's a tool that if he was to just publish that on chain and maintain the front end website for it, a fact pattern very similar to Tornado Cash, I think he would be one of many potential developers who could be the next target of the Southern District of New York in their, rogue, effectively prosecutions of developers, non-custodial developers for unlicensed money transmission. So I think even though the jury was hung on the sanctions verdict and the money laundering verdict, there is still, in that unlicensed money transmission charge, tons of danger to U.S. developers. And when we're talking, like David Hoffman and I were talking, and Amanda earlier, about this being in some ways a good news story, it's only good news because we now know what we're fighting. What we're fighting is very dangerous, and we now know exactly how we need to fight it. We need to focus on that 1960 statute, and we need to focus on the Blockchain Regulatory Certainty Act and amending 1960, and on civil challenges like Michael Llewellyn's to force the DOJ to come into reason with FinCEN's guidance, so we don't have this, schizophrenic interpretation of the law, and developers have no idea whether they should listen to the regulator who's going to give them a license or the prosecutor who's going to arrest them, even if the regulator told them they didn't need a license.
Is there anything developers would need to consider right now if they're actively developing, or do you think it's better to just sit tight for a little bit, wait out for these appeals?
Yeah, this is the crappy thing, is like, I want to tell you that if you should come to America, you should be in America, you have a First Amendment right to publish your software, but there's still this looming threat. And you may not want to be the guy who signs up to be the next, test case for a bad legal theory, because you might not want to risk jail time. You might not want to risk any of that. And I don't blame you for that, right? And the reality is, then what do people do? People want to build the cool stuff they want to build, the stuff that actually they're building for the right reasons, because they believe in human dignity and peer-to-peer transactions and self-custody of assets. But they build it quietly. They maybe build it overseas. They don't talk about their stuff. It certainly doesn't get, anywhere near members of Congress or agencies. And then we just end up further apart. And we end up kind of like we were in the last 4 years, where you had Gary Gensler going after good actors and nobody wanting to come in and get regulated because, Jesus, you just get arrested. Like, that's a really bad outcome. Developers feeling the need to develop in secret, not talk about their stuff because they don't think there'll be sensible treatment from the state. And we're still there. It's getting better in some dimensions. Like, we haven't talked about the SEC on this, and I'm always grateful for a podcast where we don't have to talk about the SEC, but we should talk about how Hester Peirce just gave an incredible speech defending financial privacy. Like, the SEC has done a 180. She basically said the Fourth Amendment should be interpreted like it was in the early days, back when you could pay somebody with coins, person to person, hand to hand, with nobody else being the wiser. Like, that's the right interpretation, I think. That's the kind of America that I sign up for. So the SEC is completely changed. I'd love for the DOJ to completely change, but it's an even slower moving, more lumbering beast, perhaps. But to our optimism earlier, I think we've figured out where we need to target.
Thank you, Peter. I think we could probably bring up Sebastian.
Hey there. Let me see if my mic works. I guess not.
We can hear you.
Yeah, we hear you.
Okay, cool. Yeah, so thank you, first of all, for the space and supporting this case. I also have questions in a similar direction along what this means for developers right now. And more specifically, like, do you see this case as something that was unfortunately still around from a previous kind of obviously anti-crypto regime? And, now we have a new self-proclaimed pro-crypto regime ruling the US, and, they won't bring up new charges? Or does this mean for, me being a kind of Swiss-based project that, maybe I'm the next one? Because frankly speaking, the money transmission charges, and it was very interesting, the B1C clause that you highlighted here. So it's not as random anymore, but still, I would argue that it's much easier to frame a wallet or anything like that as a money transmitter. And it's obvious that illicit funds or proceeds from illicit funds will touch MetaMask, they will touch Safe, or they will touch Uniswap, and they will touch Aave, right? So, yeah, is this more kind of worst case thinking, or do you think, no, this is actually a practical concern that even in the current regime, projects might still get renewed prosecution cases?
So I think that, of course, this indictment was filed under a previous administration, right? Biden's DOJ was a DOJ that issued the indictment. But Trump's DOJ has a chance and has had chances to dismiss this case, to take a different tactic in this case. They have had control over the past year over what has gone on in this case. And many of us have appealed to the DOJ under Trump to take different positions in this case and even dismiss the charges. And right now, the decision point that the DOJ currently has is whether to retry Roman on the 2 charges on which the jury hung. That is a Trump DOJ decision that they can make. They can say, we're not going to pursue this case further. We are going to let it lie. And Roman will do his appeal on 1960, and we won't hear about the other charges again. Or they can decide to bring them again. And I think Peter made this point earlier. The Southern District of New York tends to do its own thing. They are often a bit kind of like cowboys on finance cases in particular. So it could be the case that they decide to do what they want to do. But there is an opportunity here for the administration to stop this from going any further. There's an opportunity for the administration to assist in making sure that the law gets changed, as Peter said, in passing the Blockchain Regulatory Certainty Act, in making sure 1960 gets changed. They could do another memo, just like the Blanche memo. They could do another one that says, this interpretation of money transmission is not accurate, and the DOJ will no longer pursue this theory of money transmission going forward. Those are things that this DOJ can do to right this wrong. And one of the people who asked a question earlier shouted out, Alex Kurtsev is still being tried in the Netherlands. He has his appeal ongoing right now. And in that case, the appeal is a total redo of the entire trial, unlike here. So there's more to be done in that case as well to make sure that there isn't bad precedent set, not only here, but also in the Netherlands.
I'd add another thing that I brought up Michael Llewellyn a few times throughout this space, but Michael Llewellyn's suing the DOJ for clarity on this legal issue. And Trump's DOJ, so that civil action started under AG Garland, Biden's DOJ, and is continuing now under Pam Bondi, Trump's AG. And nonetheless, they pushed to dismiss Michael Llewellyn's case for lack of standing, saying he doesn't face a credible threat of enforcement, while simultaneously they're continuing to prosecute very similarly situated developers like Roman Storm. And so, another thing, Michael Llewellyn has asked if they would agree to say that his course of conduct, which is publishing smart contracts, maintaining non-custodial front-end websites for the tool that he wants to build, whether it is inside or outside the law. Just say it, right? Instead of dismissing this case, just tell us. And they've so far refused. So there is something big, I think, that could happen there. There's something big that could happen with, as Amanda said, the decision whether to retry the hung jury parts and how the appeal is handled, because I'm sure Roman will appeal. And there is, of course, something for the Trump administration to do vis-a-vis Congress and the passage of the Blockchain Regulatory Certainty Act. The president's working group for digital assets, the group of folks within the administration who are tasked with making America the crypto capital of the world, endorsed the BRCA. And Trump has said he will sign that if Congress passes it. And that is, again, the law from Congress that would say, it wouldn't be retroactive. It wouldn't solve past stuff like for Roman, but it would say going forward, if you're a non-controlling blockchain developer, and there's a good definition of that we've helped work on. If you're a non-controlling blockchain developer, you are not a money transmitter. You are not engaged in money transmission. You are not liable for unlicensed money transmission. So that would be a quick fix, and it's already passed the House, needs to pass the Senate. We'd love any more support from the administration we can get, but they have already, said that they want to see it passed. They want it on the president's desk, and that would make a big difference. But there's a mixed story here. I do think the Deputy Attorney General Blanche's memo could have been clearer, could have been stronger. They could have applied pressure to their own DOJ to change tactics on these cases or even drop them. And we're sort of in an uncomfortable limbo right here. And that limbo goes all the way to you in I think you said Switzerland, because as we said at the start of this space, the Southern District of New York's theory is that if we can run your software in our offices in the Southern District of New York, we have venue to bring you in and charge you with unlicensed money transmission.
I guess everyone should support this case to the maximum extent. What can projects do, maybe as a last question from me? Like, is there anything that, obviously we're not legal professionals, we appreciate your work, anything we can do?
I'd humbly ask that you, stay in touch with Coin Center and donate to our mission if you support it. I'll speak for Amanda. DEF definitely deserves donations as well. They do incredible work. And if Roman brings his appeal, and I'm pretty sure he will, I'm sure he'll need more. I know it seems like a lot to people who aren't familiar with how expensive the American legal system is, but that is what it costs to mount a robust defense to these kinds of abusive prosecutions. So Roman will probably need financial support again in the future, and you should support him as well.
Fully echo that, and just add that Alex Pertsev also needs funding and has a separate fundraising mechanism through Juicebox. You can donate to either of their defense teams through Juicebox. You can also send crypto directly to wallets set up for this purpose. But like as Peter said, appeals are very expensive. We are talking about like $1 million as a starting point for an appeal. So it is the best thing that anybody can do is assist in Roman's appeal and Pertsev's appeal in the Netherlands.
Oh, and I'll briefly say one other thing. If you decide to donate to Coin Center and you want to do it to protect your privacy as a donor, which in America you have a First Amendment associational right to, anonymous donations to a good cause, you should use the weirdest DeFi privacy protocols you can find to do that. Because then when we receive that donation, we have an argument that we have standing in court to challenge any kind of attack on that tool, because we as a nonprofit with First Amendment protections have a right to receive donations via that tool, and you as an oppressive regime are trying to stop us. So please give us money in weird and wonderful ways on chain that protect your privacy and support our nonprofit mission.
Sick. So I think next up would be Wade. I think unfortunately after that we're probably going to have to close up the space, as David and I both have things to do and articles to write, and I bet everybody else wants to start to get going as well. So Wade, why don't you go ahead?
Yeah, I wanted to come on and well, there's a ton of people that I see like in the audience that have done a whole lot of great work towards this and will continue the fight at this point. I see a lot like Tay and Rebecca, of course, you, Peter, and all that. But I think Preston's in there somewhere too. But I wanted to give my
BPI.
I wanted to give special flowers to Amanda and the DEF team, Laz and Gavin, Max, and like I know firsthand they have just been doing the absolute yeoman's work of like months and months and months of deep diving into 1960 and like doing this when it didn't have a lot of spotlight on it. It was, probably still is quite unsexy work. But they've just done amazing work through, and I guess Jake to add on to that. And I think that like this is going to be pivotal going forward. And we're on the precipice of something right now because of the work that all these people have laid down. We have clarity going into the Senate with the BRCA attached to it. All of your senators right now are on August recess. That means they are like in your neighborhoods. Many of them are hosting town halls. Like everything's teed up right now because of where we are. Even Commissioner Peirce, this full-throated endorsement of privacy protocols, like we can pass this and we can put this to rest for the future. Obviously, Roman's still going to have to contend with it. I think, in some way it helps him to have clarity past the BRCA too, a tangential way, obviously. But like we have the momentum right now, and like you guys said, it's kind of a glass half full situation. So I work with Stand with Crypto, so like DM me if you want to get in touch with your state chapter and get letters to your senators, or know when they're hosting their town halls, or get in front of them. If you're developing open source on-chain software and you want to try to get actually in front of your senators or House reps for a meeting, we'd love to do that for you. So now's the time to act, but we're all here because of the yeoman's work that DEF and so many other folks have done. So I know it's not like cause for celebration writ large, but like we're on the verge of something really special here. So thanks to all those involved, and make sure to make your voice heard. Holler at me if you need a line into that.
And thanks to Wade and Stand with Crypto, who also made it incredibly persuasive for politicians to understand like what good policy looks like and why civil liberties are important to fight for, and sane crypto regulation is the goal.
On that note, thank you all for joining. Thank you, Amanda and Peter, for taking the time on such short notice. And yeah, David and Peter are actually going to be on Bankless in about a half an hour. Tune in there if you want to hear more about this this verdict. Thank you all for coming. We are still going to publish some articles going more into depth on what happened and summing everything up. So you can also follow our profiles to stay up to date on that. And yeah, have a good evening, everyone. Thank you.